Hello and welcome to this second talk on the new subject access code. My name's Declan O'Dempsey and I'm a barrister from Cloisters Chambers. I want to take up where the last talk finished, namely in discussing the electronic storage that may take place. So data can either be archived or put in the deleted items folder. When files are archived, they may be sent to storage or copied to backup files, but the controller should have systems to find and retrieve personal data that's been electronically archived or backed up. Emails which have been archived continue to count as data, and so there'll need to be a system to search them as well. The deleted items folder does not count as a deletion proper because you can still retrieve the material in it, so that again there should be a search made of data that's contained in those files. By contrast, files and data which has been deleted is in a different position. If the controller deletes personal data held in electronic form by removing it as far as possible from their system, then the fact that expensive technical expertise might be able to recreate the data does not mean that the controller has to go to that kind of effort when confronted with a subject access request. The Information Commissioner wouldn't seek to take enforcement action against somebody that's failed to use extreme measures to recreate a previously deleted personal data file held in electronic form. In other words, the Commissioner doesn't expect organisations to spend time and effort reconstituting information that they've deleted as part of their general records management. It's quite another matter, of course, if there has been an attempt to delete personal data after the request in order to avoid the request. A lot of employers allow their employees to bring their own devices to work, and the Commissioner recommends as good practice having a policy restricting the circumstances in which staff can hold information about customers, contacts, or other employees on their own devices or in private email accounts. Some employers allow staff to access their systems remotely, but most are likely to prohibit the holding of personal data on equipment that the organisation doesn't control. If the controller does allow staff to hold personal data on their own devices, they may be processing the data on behalf of the controller. Now in that case, the data would be within the scope of a subject access request received by the controller. The purpose for which information is held and its context is going to be relevant for this purpose. The Information Commission wouldn't expect the controller to instruct staff to search their private emails or personal devices in response to a request, unless the controller's got good reason to believe that they're holding personal data which is relevant to the request. I want to turn next to the period of time within which a response must be given. And the controller must respond promptly and in any event within 40 calendar days of receiving the request. It's an obligation to act without unreasonable delay, but it doesn't oblige the controller to prioritise compliance over everything else. Also, the controller doesn't need to comply with the request until the fee has been received. Under section 7.4, if the controller cannot comply with the request, without disclosing information relating to another person who can be identified from that information, then the controller's not obliged to comply with the request unless certain conditions are fulfilled. The first of these is consent. The other individual must have consented to the disclosure of the information, and that consent must be to disclosure of the information to the person making the request. Alternatively, it must be reasonable in all the circumstances to comply with the request without consent of the person who's identified. By section 8.7, the other person can be identified from information if they can be identified primarily from that information, but also secondarily if you take that information and any other information which the controller reasonably believes is likely to be in or to come into the possession of the person making the subject access request. Chapter 7 of the Code deals with the aspect of information which talks about other people's lives. The Code gives an example which may be of interest to human resources. An employee requests from the employer a copy of her human resources file, and the file contains information identifying managers and colleagues who've contributed to or are discussed in it. The employer is going to have to reconcile the requesting employee's right of access with the third party's rights in respect of their own personal data. Now, generally this can be done by redaction of information which will identify the person, but of course it's worth remembering that a person will be identified for these purposes if they can be identified by, as it were, triangulation from information that the data controller provides, but information which they've already got in their possession. The controller has to balance the person making the request's right of access against the other individual's right of access in respect of their own personal data when trying to determine, in the absence of consent, whether or not they should make disclosure of the personal data. So it's possible to envisage a three-stage process. First of all, the data controller should consider if it's possible to comply without revealing information that relates to and identifies the third party. Secondly, if, of course, the third party consents to disclosure, then it's unreasonable not to make disclosure. Thirdly, if there's no consent by the third party, then the controller must decide whether or not to disclose, and this has to be done on a case-by-case basis, and there cannot be a blanket policy of withholding according to the Code. Secondly, the controller can't refuse to provide personal data simply because the data is obtained from a third party. Whether or not disclosure should be made is a question of whether it's reasonable to do so, and that requires considering certain factors. The factors that need to be considered include questions of confidentiality. And for example, the following relationships are generally confidential in relation to information. The Code lists employment as one of these relationships, the relationship between employer and employee. It also lists counsellor and client, bank and customer, and doctor and patient. The question of reasonableness is determined by considering all the factors, and other relevant factors include whether the third-party information has previously been given to the person making the request, or is already known by them, or is generally available to the public. In those circumstances, it's going to be more likely to be reasonable for the controller to disclose. So, for example, if the third-party information relates to a member of staff acting in the course of their duties, who is well known to the person making the request through previous dealings, then that information is more likely to be disclosed than information relating to an otherwise anonymous person. The second factor that the code talks about are the circumstances relating to the person making the request. And here, the issue is the importance of the information to the person making the request. This needs to be balanced against the need to preserve confidentiality for the third party, but that in itself has to be weighed up against the person making the request's right to access of information about his or her life. And depending on the significance of the information to the person making the request, disclosure may still be appropriate even if the third party withholds their consent. Special rules apply in relation to health, educational and social work records, and normally these should be disclosed. The code deals with this at page 32. Section 7.5 deals with sources of information and the risks of identifying somebody as a source. So information identifying the third-party individual as the source of the information sought by the request does count as identifying the third party, unsurprisingly. The other important point to bear in mind is that even if consent is withheld and it's not reasonable to disclose the third-party personal data, this doesn't excuse the controller from communicating as much of the information sought by the request as can be communicated without disclosing the identity of the third party, whether by omitting names or other identifying details or otherwise. So this would cover things like redaction. So the controller essentially has to have regard to all the circumstances, including the duty of confidentiality owed to the third party, the steps taken by the controller aimed at seeking that person's consent, whether the other person's capable of giving consent, and any express refusal by the third party. But it's important to remember that those are simply factors.